Hi guys! Welcome to our first educational video. Before we start our discussion, please like and share our video. I'm Arceli Bogol. So for today, we are going to talk about the Intellectual Property Code of the Philippines. First, let us define what is the intellectual property. So, the intellectual property refers to the creations of mind such as inventions, literary and artistic works, designs and symbols, name and images used in commerce. So, for example, you have created a brand name, or should I say logo for itself. So, it is for your business. All of that is the creation of your imagination and a creativity of you, a person, or a group, and it is considered as intellectual property. So now, we are going to move on what really our topic is all about, and that is the Intellectual Property Code of the Philippines. So, what is the Intellectual Property Code of the Philippines? So, the Intellectual Property Code of the Philippines is also known as Republic Act 8293. So, it is authored by the late Senator Raul S. Rocco, signed into law on June 6, 1997, effect on January 1, 1998. So, an act is prescribing the intellectual property and establishing the Intellectual Property Office, providing its power and functions, and for other purposes. So, in other words, the Intellectual Property Code of the Philippines is made to protect and secure the exclusive rights of the scientists, inventors, artists, and other gifted citizens to their intellectual property and creation. Moreover, we have three types of intellectual property. First is the trademark, second is the copyright, third is the patent. So, let's talk first about trademarks. Trademarks is a sign capable of distinguishing of goods or services of one enterprise from those other enterprise. So, a word or a combination of words, letters, and numerals can perfectly constitute a trademarks. But trademarks also consist of drawings, symbols, and three-dimensional features like shapes, packaging of goods, then visible signs like sounds, fragrances, or color shades used as distinguishing features. At the national or regional levels, trademark protections can be obtained through registrations by filing an application for registration with the National or Regional Trademark Office and paying for its required fees. At the international level, you have two options. Either you can fill a trademark applications with the trademark office of each country and which you are seeking protections, or you can use the World Intellectual Property Organization. In principles, trademark registrations confer an exclusive rights to the use of registered trademarks. So, this implies that the trademarks can be exclusively used by its owner or licensed to another party for using return payment. Trademark rights are private rights. It can be enforced through courts. The term of trademark registrations can vary, but it's usually 10 years. So, it can be renewed indefinitely and payment for additional fees. Think of the Nike shoes, the Apple logo, the Amazon name with smile / arrow below it, the FedEx logo that uses letters with colors and a hidden arrow. That is some example of trademarks. It is used to identify the source of good or services so that we can distinguish it from others. So now we have three types of trademarks. First is the service mark, second is the design marks, third is the certification marks. Let us talk first about service mark. Service mark, it is the same as trademarks except it identifies and distinguishes the source of services rather than goods. The design marks, it is to protect your logos or your styling asset. Third one is the certification mark. The certification trademarks is very different from company's logo and trademarks because it is the guarantee to consumers that the products has undergone rigorous assessment. So all of that is generally referred to the umbrella name trademark. So now we are done to three types of trademarks. Let's move on to what is the difference between trademarks, copyrights, and patents. A trademark is different from copyright or patent. Why I say that there is the difference between the three? So it is simply because that trademark is generally protects the branding, while the copyrights protects an individual artistic and literary works, and the patent protects the inventions. For example, an Apple created an iPhone, so it is registered as patent for the phone itself. So, and a trademark is the iPhone, for it is the brand name. Or when Netflix created a new film, so it is registered as copyrights for the film itself. While the film is marketed or distributed, so in connection with the Netflix brand, so it is called the trademark also. So next, why we need to protect our trademarks? So it is because by protecting our trademarks, it is essential for making sure that no one else comes along and takes advantage of the hard work you've done on your brand. For example, if someone tried to open coffee shop chain under the name of Starbucks, which is Starbux, using logo that looks similar to well-known Starbucks logo, so Starbucks can take steps to prevent or stop by enforcing its trademark rights to its name and logo. And now we're done at trademarks. Let's listen to Mr. Ace as he will discuss to us what is copyright.
Hi guys, in this video I'm going to discuss about copyright. So, what is copyright? Copyright refers to the legal right of the owner of intellectual property. It gives the owner of a work the right to say how other creator can use the work. So, copyright is the intellectual property that governs or protects from the creation of mind, such as the invention, literary, and artistics, including computer programs. The copyright is automatically works when the form is in a tangible form. So, it means if the form is not in a tangible form, the copyright will not apply because the copyright does not apply to ideas that have not been recorded, work that have not been written. So, the copyright, it only applies in the tangible form. When we say tangible form, it must be a visual or being created by an author and being published. The copyright law is, it also helps to protect the author's creation or the work from the other people that are trying to copy their work without permission. Because if an individual just copy and publish the work without permission to owner, so probably an individual or other creator could violate the law, which is the copyright. So that's how copyright works. These are the work that covered by the copyright. We have the books, newspapers, musical composition, choreographic works, dramatic works, and article. So these are all is an example of a fixed form or a tangible form that being created by an author or published. In the copyright protection, there are two types of rights. First is the economic rights, and we have the moral rights. In the economic right, we have the public display right. Public display right is the right to display or show the work in a public. So like for example, you're watching a TV show, so the author of it or the creator of it is given the right to display it in public or display it in a television. In economic rights, we have also the distribution right. Distribution right is the right to distribute the copies of the work in public. For example, copies of a book are being distributed in a public, so the author or the creator of a book can sell it as well and earn money because the author had given the right. We also have the public performance right. So the public performance right is the right to recite or act in public. Like for example, singing in a public or dancing and other work that performing in public. So those are all covered by copyright. Reproduction right. So the reproduction right is the right to copy or duplicate a work in a fixed form or in a tangible form. For example, an author is photocopying a book. So the author have given the right to copy or duplicate or make their own copies. Modification right. Modification right is the right to modify the work to create a new work based on a pre-existing work. Modification right is also known as the derivative. So when we say modify, it means to improve or to arrange the work that already existed. So let's say for example, creating a new music composition. So in that music, there will be an improvement and arrangement. So that's what we call modification right. Moral rights. All rights are the personal rights that connect the creator of a work to their work. In moral rights, we have the right of attribution. Right of attribution requires that your name is always shown with your work. So like for example, you have published a work or a film, so your name should always appear next to your work. Limitations in copyright. Fair use is a knock of copying of copyrighted materials for purposes such as commenting or criticizing a copyrighted work without the permission to owner. So fair use, it's used as a defense under copyright infringement. So when we say copyright infringement, this is the use of copyright protected work without the permission of the copyright holder. So let me give you an example of violating copyright. A content creator is downloading a music or a movie without paying for their use. Another example, copying a written work or like books or any literary works without an agreement to its owner or author. So that is all guys. I hope you've learned something about copyright. So in the next topic guys, Mr. Gelacio will discuss about patent.
Hello guys. So we discuss about the intellectual property of the Philippines, which there are three types of intellectual property. The two one that they discussed by my core member, that the following are the trademark and copyright. So I'm here to discuss about the patent, the part of intellectual property, which also refers to the creation of minds such as invention, literating, and artists, which work symbols, names, or image that used in commerce. So, we tackle also the intellectual property codes, just like sample that last tackle in the part of intellectual codes in the Philippines is also known as Republic Act 8923 that signed by Raul S. Rocco and signed on June 6, 1997 and effective in January 9, 1998. So guys, since we tackled the two types of intellectual property such as trademark and copyright, so we will tackle about the meaning of patent. So, what is patent? Patent is a type of intellectual property that gives its owner the legal rights to exclude from making, using, or selling any invention limited period of years. So, for the good example of patents are the following. The example of the patent most commonly is the products. So when we say products, this is common thing that we manage to show in every ways or uh, every individual company that they show their individual products for the goods of the people that make make them or help other people to provide it and consume it by the consumer as well. The other reason why products is the common thing that used in the patent is because the the products has have an owner and they legalize it to include form making or selling as well by limited period of time. So there are two types of patent or patentability as well. The two terms are the following: the patentability invention and non-patentability invention. So let's talk about the patentable invention. So patentable invention means is any solution of problem in any field of human activity to be shown or improved by the industrial. So we say patentable invention. These are the example like something improving the process of the materials or products that they should manage or use legal, well, also legally as well. While the patentable invention, which means to be excluded from patent protection, such as following, just like for example, discovery of science and math methods or methods of medical treatments for the health of the people or some knowledge as well. Experiments of plants of animals or they sometimes conduct a breeding of animals or something else is as long as in the part of experiment. And lastly but not the least, contrary to public or morality or manage the public, public formal and morality as well at the same time.
So, at this point of time, we hope that you learned something about the Intellectual Property Code of the Philippines. So, on behalf of my companions, Mr. Roselar Gelacio, Mr. Ace Graham Bernardo, and yours truly, we would like to say thank you for being with us today, and we appreciated that you took time to listen to our presentations. So don't forget to like this presentation. It is a big help for us. So, thank you guys and keep safe.